Hi. Thank you for allowing us to present our work here. And special thanks go to Denis Marigot for actually telling us about this community. In 2020, Slovenia had a super election year with national elections, presidential elections, and local elections. And our team was contacted by the State Election Commission regarding the national and local elections. So let me first explain who the team was. So we are actually two computer scientists and one professor of law. We're not all computer scientists, but the computer scientists did the computer science work. So that's me, Andrej Bauer, Katja Berčič, who is going to appear somewhere in the video feed now. And the third author is Saša Zagorc, who is a legal expert, and he was also he's also a former member of the State Election Commission. So the task that was given to us by the by the State Election Commission was verifying or ascertaining the correctness of the program that calculates the results of elections. It's just one module in a much larger software system, but we were only focusing on this one. So in fact, there were two questions specifically asked. And the first one was, is the law correctly transcribed to code? Slovenia uses a proportional system with some local modifications, and it was not entirely clear that the program, that the intent of the law was correctly transcribed. And the second question was, well, assuming the intent is correct, does the code contain any further bugs, errors that would cause the elections, the results to be incorrect? I would like to emphasize that at all times we have to be aware that these two questions are actually just proxies for the main goal. And the main goal, because the main goal is not to make the program work correctly. The main goal is to get the correct results of elections certified by the by the State Election Commission. So this is important because sometimes one can suggest solutions that are even more suited to this main goal, and I will point this out later on. So how did we address this first question, which is the law correctly transcribed to code? Now, I'm just going to discuss a couple of points, and you can read the paper for more details of what were the points that we found contentious or interesting, or the ones that required special attention. So one of them was the fact that the law contains passages which to a mathematician or a programmer will read as straightforward algorithmic instructions. So this is somewhat reserved, reverse situation from what we had before, what we had yesterday, when it was mentioned that sometimes you can have code that looks like law. So there, in particular, Article 90 of the national elections law states that a certain number should be rounded up to an integer. This is actually not the way this is read by a typical programmer is going to end up with a software bug. Oops, sorry, I didn't want to go there yet. Because the actual thing that needs to be done is you have to find the next integer larger than the number, and this is not precisely the same when the integer already is when the number already is an integer. So anyhow, the details are not important. What is important is that this reads to a computer scientist or a programmer like a straightforward instruction that needs to be coded. And in fact, when we told the programmers that there is a problem here, possible problem here, they said, well, but we can't do it in any other way than what the law prescribes. So I think we have a situation where they were reading the law as code, and this was not intended by the law. So the way to convince them was to give them a stress test for this system that actually put 91 people into a 90-seat parliament. And then they said, okay, this is serious enough. We understand we need to change. The other noteworthy issue that we faced was a sort of lack of instructions. So there is one article, Article 93, which discusses, which explains how the seats allocated by the DON system are to be distributed amongst the constituencies, and it's just unclear. It's very difficult to understand what it says, and this is a dilemma that was previously already recognized by legal experts, and it just reiterated itself when we studied the law from this mathematical point of view of how to transcribe it into a computational procedure. The other thing that we discovered was that the law does not anticipate all possibilities that could happen. Now, admittedly, some of them are very improbable, but the program must do something. It must be complete. The program will always do something. And so then the question is, what should it do in some unanticipated situations? And these involve ties, complicated situations where two parties, two constituencies, or two lists, or two candidates receive an equal quantity, and then you don't know how to sort them. And this is particularly complicated in the law that we considered. And we discussed this further in the paper. So moving on, how did we verify that the code does what it's supposed to do? How did we try to find bugs? Now, there are three standard ways of doing this in software assurance, quality assurance, and I'm going to discuss each one briefly. So the first one is formal verification, although I think for this forum, it's better to call it mathematical verification. And the idea is that you write down a mathematical statement called specification, and then you prove mathematically that the program does what the specification says it should do. We did not use this method for at least three reasons. The first one is that we didn't have direct access to the code because it runs in a secure environment, and verifying any other code other than the one that's actually used, it makes little sense. The second one is that it's not clear where we would get this specification from other than from the law, but that requires the kind of interpretation that we already had to do with respect to the program. And so even if we had it, there would still be doubts as to, is this the correct specification? Also, it seems like the specification is at least as complicated as the program, if not more. So it wouldn't really instill any additional trust into the correctness of the program. The second standard way is testing.
Hello.
Yes.
You have 2 more minutes.
Hello.
Hello. You have
Hi. Thank you.
2 more minutes. 2 more minutes. Okay.
Yes, I understand. Thank you. Yes, I understand. Thank you. So the second one is testing, where we perform some stress tests and compare them against reference results. And we did this, and this was useful mostly for debugging communication processes, not so much for the program. The program worked well. And the third one is redundancy, where we use several programs implemented independently and compare their results. And we did this too. So let me tell you what happened in the national elections. So because of COVID, there was a delay in installing the new software. So the old software was used. And this software also published temporary results on the web, unofficial. This piece of software contained a bug. This was software that we did not verify, and it published results that were not incorrect. And once we discovered this, comparing the new software and our reference software, the matter was resolved in a matter of minutes. But of course, it caused a real media storm, and we were thrown into the public arena, and we were not really ready for it. And it was just me at the time. It was a band of one. So that's something that I would like to communicate as advice to experts: be ready to go public. Then in the local elections, we decided that we need a much more proactive stance regarding public communication, and so we did that. And we also devised something called verifiable certificates, which yesterday were called justifications. On several occasions. And these are documents. Here I'm showing you an example of the thing that we published for local elections, where you can actually see all the numbers involved in the election procedure, and a determined person could verify these with a calculator in a reasonable amount of time. And we think this is a very good idea, and it's applicable in many other situations apart from law, such as tax returns or social benefits. And I think it's worth promoting it. So in conclusion, if there are any lessons taken from this, I would say the lessons for the computer science expert is not to pretend that you can be insulated from the real world. In fact, the whole point of being the expert is so that you can interact with the real world from a position of trusted authority, and you should prepare for that. And software also, the validation of software behind the scenes is not nearly as valuable as something that is connected to some form of public communication and outreach. And lastly, as I already mentioned, we would like to promote the idea that verifiable certificates can be quite valuable because they, in fact, allow any person with sufficient knowledge to verify results rather than having to trust a piece of software. So this seems like a good possible policy that could be used in many situations. And I think my time is up, so thank you for your attention.
Thank you very much. So now the floor is for Professor Jurij Toplak from Maribor University, and he is also an adjunct professor of constitutional law and an election law specialist at Fordham University. And I have to keep talking because he's not yet with us.
I am here.
Yeah, he is. Okay, very welcome. You have 10 minutes.
Thank you. So first, congratulations to the organizers for this wonderful conference, and thank you for inviting me to participate. I regret I can't be with you in Brussels and meet you in person. I really enjoyed reading the paper, which shows what happens when computer experts interpret the law, something that many of you have discussed over the last few days. The paper describes what happened in the back of the, we can say, computer defect or error or failure or bug. These are the words that the national election president used in the last parliamentary election. And that event really hurt the trust in electoral authorities and in the process. But it was, if I understand correctly, it was not a computer defect or bug. The authorities let computer programmers interpret the very unclear law, and the programmers honestly believed that their interpretation was the correct interpretation. So after the 2022 national elections, the Electoral Commission shared names of the 90 elected parliament members, and 10 days later, before the names were officially confirmed, it announced that 6 seats have been wrongly assigned due to a computer defect. The software they used wrongly calculated who was elected. The national election president explained that it was impossible to calculate all the seats correctly because a manual calculation would take weeks or for a dozen of people, which was ridiculous because for years we've been doing it manually before authorities started using the software. But so the next day I published on YouTube a video in which, with a simple calculator and a pen, I calculated all the seats in less than 3 hours. And 19 years ago, one computer science student developed a software that calculated all MPs correctly. But 19 years ago, electoral authorities said that they prefer doing it manually, and they didn't want to use that software. So the paper the authors presented shows what actually went wrong with the software. And if I understand correctly, the authorities let the computer programmers interpret the law. This is something we've been discussing for 2 days. For example, the authors in line 144 of their paper say, we detected misleading phrasing in the law. And in the line 2012 of the article, they say, there was unclear selection of constituencies. Yes, in the ideal world, the law should be clear. But in real life, law allows multiple interpretations, and this law here allowed 2 different interpretations. This is not an exception. It is happening every day with many laws and legal provisions. They allow multiple interpretations. And when this happens, it is the executive government or the courts to interpret it. And on these 2 provisions which are really vague and unclear. In the 90s, the electoral authorities have chosen one of the possible interpretations. None of them was more sound than the other, but authorities chose one interpretation to be the correct one. Somehow, when authorities hired computer experts to develop the program, they didn't make it clear to them which was the correct interpretation. That's how I see it. With the paper, I would suggest maybe a few possible improvements with the structure of the paper. The paper would benefit if it used the standard structure with a literature review in the beginning. If the topic has already been discussed in the scholarly literature, we usually cite the publications that have covered this topic earlier. For example, the electoral system of Slovenia has been presented at least twice in the Electoral Studies Journal. Not in this detail, but it has been covered. And there's other publications that have covered Slovenian electoral system, similar software programs, similar legal, mathematical, computational problems that have occurred in the past. And this would, if authors include this in the paper, this would facilitate further research for readers who are interested in the topic. And I agree with other reviewers that the paper is ready to be published, and it is also it is very beneficial because it will other readers and scholarly community will be able to have a record of what can go wrong with electoral software. This would be all from me, and maybe we can continue our discussion or questions. Thank you.
Thank you very much. I propose, because we are again running late, of course, because the discussions are so interesting that it's very difficult to contain them, that I take questions, that I take them one after the other, and then the authors get a last word to respond. Not all at the same time, please. So this is a very technical paper. Can I ask you a question? Do you understand exactly what was the issue here? Why is it relevant to the conference? Any suggestion?
Okay, I can hear you now. Can I speak?
Yeah, one sec. I'm asking the audience whether they can figure out why this paper is relevant for this conference. Liria.
For me, it actually reminded me of the paper from last year's conference that was Mark Burden et al., which was the rules as code and the sort of some of the issues that arose with interpretation there, and also Denis, your paper as well, also from last year. And both papers at the time, made me think a lot about the questions of interpretation, right? Like when you code something, you have to make choices. And Denis, I remember your paper was particularly clear about this. And so I think it's the same thing, right? To me, when I listened to the presentation and then the response, there were different potential interpretations of this electoral law. Often when you have to code something, you have to interpret them in ways that it might not, the ambiguities become more evident, if you like, and you need to have some process for dealing with that, whether that is, having a specification in the middle which has some status, which was, not considered, not pursued, or something else. So I suppose just taking, I guess, particularly the lessons from your paper, Denis, is the idea of, well, how do you document this and have it have some kind of status, particularly in a context like elections. I mean, this sounds like it became very public, and at that point, it's sort of too late, right? Because people are losing trust in the system and in government. Whereas if in the process of programming, you've documented those decisions and gotten potentially some kind of ministerial level, at least authorization for, yes, these are the interpretations and so forth, and that's all transparent and open before the election, potentially then you mitigate some of the controversy around what the right interpretation is and old versus new software. So to me, that's the connection, I think.
Yeah, great. I absolutely agree. It would be very interesting to hear the response of Professor Bauer to the comment, to the feedback of Jurij Toplak, because I understand Jurij as saying that he finds that in the paper it is rendered as if computer scientists make a decision on how to interpret the law, whereas he says this interpretation should be dictated by the legislator. So I'm very curious about your response.
Okay,
and the last word is to you, of course, now.
Yes, okay, so just to respond quickly. So first of all, thanks to Jurij for the great suggestions. I think we will definitely take them into account. And I would just like to, first of all, clarify one point. The errors that happened did not happen because of our interpretation or anybody else's interpretation. The interpretation was the one that Jurij was talking about from the 90s. It was just a very stupid error bug. There was one line of code that was wrong, and this was in a piece of software that we did not verify. This was old software that was supposed to be thrown away, and then it was used again. Now, regarding this question of interpretation, I would like to, first of all, maybe make it clear that as a mathematician and computer scientist who does not know anything about the law, really, and I think I am typical in this respect, when I walked into this, I naively expected that the law will be precise, and moreover, that humans do not really have, like humans like me, the programmer, that I will not be asked to, nor should I be authorized to interpret anything. I was fully aware I should not be making arbitrary decisions, but we were forced to make them because something had to be done, and the information that was available to us did not specify what to do. And in fact, I think we discovered some of this business with ties, how to carry out ties. I don't think this was noticed before by anybody. And I would be very interested to speak to legal experts and to, first of all, try to explain what the problem is. It's a technical problem. I don't think they're aware of it. So I think it would be very interesting to do this. So I would just say the error itself is not related directly to interpretation. It was a straightforward programming bug. And this business of interpretation is, of course, very important. And what is very important is that when a computer scientist walks into this, they will have a completely different idea of what needs to be done. So that's important to keep in mind. I think for somebody who's not a legal expert, it's a new world. Yeah. But I would also like to give a chance, maybe quickly, to my co-author Saša to respond to anything that he'd like to respond to.
Yes,
please.
Thanks. Thank you. I would just like to add up maybe a little bit of legal angle. First of all, I agree with Jurij's comment that interpretation should be left to executive authorities and at the end to the courts. However, they were facing the same problem as later computer scientists, and that is that the legal setup, the legislative acts, were actually had some bugs in terms of legal lacuna, as we mentioned, and they were not precise enough. The problem is, from the Slovenian constitutional law point of view, is that and in the European electoral setting, the problem is, of course, electoral law should be in the rank of statute law. So when you have electoral formula, it should be precise enough in order to fulfill the role of the legal rules, being predictive, being clear, and being transparent. And we have in Slovenian terms, we have this, let's say, constitutional issue still open to the debate. So in the long run, I would say, in addition to the issue of public trust, I would say that in reality, the whole conundrum actually raised the public trust in a way that we found out the problem by means of help of computer science, and so we managed to create a positive feedback, and the loop was completed. And finally, my third point would be that, in a way that Andrej already mentioned, his role as a computer scientist, it goes in line with what Green and Vijuan article says on algorithmic realism. And I think yesterday Frank Pasquale mentioned this. That's, of course, algorithmic realism should be, as they say, tool for computer scientists to account for the realities of social life and of algorithmic impacts. And this is probably the main lesson to be learned from our article as well. Thank you very much.
Okay, thank you very much. I just want to add one thing. Of course, I was one of the people who looked for a replier to this article. And it's very interesting to see that all the lawyers who write about election law, they're forever writing about one particular election in the United States. Yeah, so there are 1 million articles about that and specialists on that. And I was very lucky and very happy to have found a scholar who is Slovenian, actually, who had already worked on this. And I think, and this is not, again, to go back to you for more explanation, but I think the point that Professor Bauer was making, that this is actually not about interpretation, but about a technical issue around the multiple ties that are possible, and that's a technical issue that lawyers may not understand unless it is clearly explained to them, that would be really helpful to have that out in the paper, to put that up front and to help us lawyers to better understand the impact of these technical problems, because that's what the conference definitely is about. And we're talking about democracy, about trust. So I think this is a fantastic paper. Thank you very much.
Thank you.